Good morning, everyone. Thank you for joining us today. We appreciate you taking the time out of your schedule to be here. Before we get started, just a couple of quick housekeeping items. This session is being recorded, so we'll get that out to you once we have it wrapped up. Additionally, we encourage you to submit any questions that you have in the chat throughout the presentation. We'll address those during the presentation or at the end. Um, Additionally, I am joined by Keith Hammond with the Hammond Law Center. I know many of you have met him. We've been working together since 2001. Keith works with employers on issues like wage and hour compliance, employee accommodations, workplace investigations, as well as best practices to help reduce legal exposure. So without further ado, I'll go ahead and hand it over to you, Keith.
Thanks, Myra. Well, it is a pleasure to be here again for our annual labor and employment law update. Most of you know me. For those who do not, let me briefly introduce myself. My name's Keith Hammond. I've been a labor and employment lawyer since 1999, so 27 years of labor and employment law. And frequently, I will go out and speak at presentations just like this. Whether it's with Myra or whether it's at SHRM or a SHRM-like group or even at an industry group like the hotel and timeshare industries here in Orlando have human resources groups that meet frequently and look for legal updates. Let me go ahead and share my screen here and put my PowerPoint up. There we go. So what we will discuss today will be best HR practices and avoiding litigation. And the reason that we chose that topic is because, as Myra and I were planning for today's presentation, we were discussing what the major labor and employment laws have changed or what new legislation has been enacted over the last year. And spoiler alert, the answer is none. Probably for the first time that we've ever done the labor and employment law update, there just really isn't much to update everybody on. There's no Lilly Ledbetter Act that has come to fruition like there was in 2008, 2009. There's no Pregnant Workers Fairness Act like there was in 2023 that has a whole slew of regulations that employers need to know. In fact, to the contrary, what we've seen more than anything else, have been various executive branch agencies rolling back regulations or enforcement guidance internally that was in play during the Biden administration or even the Obama administration. And that's when the agencies even have enough people to function, to have a quorum. For almost a year, the NLRB did not have a quorum among the five-member board in Washington, D.C., and therefore could not do anything other than basically adjudicate unfair labor practice charges, much like the EEOC's charges of discrimination. The EEOC lacked a quorum, lacked a chairperson for almost a year. There's a new chairperson that's been installed. And with that, there's been an announcement as to the EEOC's priorities, but really no change in the law. If you want to know what those priorities are, by the way, number one, the EEOC is no longer processing charges of what they call disparate impact discrimination. That's where you have a facially neutral policy that has a differential impact on one or more protected classes. Typically, the fact pattern you might see here would be, hey, in the layoff situation, more older workers were laid off than younger workers, even though the criteria for the layoffs appeared to be facially neutral when the company announced them. So what's on the horizon? Well, quite honestly, this is an election year, and very rarely are major employment laws passed during election years. So where does that leave us? Well, that leaves us with a 5-minute presentation on labor and employment law this go round, right? Well, not so fast. What we decided we would cover today would be best HR practices and how to avoid employment litigation. At one of these presentations fairly recently, I had one of the attendees come up to me afterward and say, hey, Keith, From our perspective in the audience, we take a chunk out of our day to attend these things. But if we walk away with one new idea or one new best practice that I can implement, when I go back to my office, it's totally worth it. And I assure you that we will have at least one, if not many, best practices ideas that you can take back and utilize starting today to help you in your role as well as to help the company. And even if that help is avoiding litigation, then that's a win. Absolutely. So what we've done is we've come up with what I'll call the top 10 list of best HR practices. And if you were to look at this list from left to right, just reading it like a book, this kind of looks like the life cycle of a typical employee. What's the very first thing that an employee does even before they're an employee? Well, they fill out an application, they sit for an interview. Once they're hired, you set their compensation. We want to be sure that we're in compliance with wage and hour laws, and I'll tell you what the pitfalls are with respect to the Fair Labor Standards Act. Throughout the employee's life cycle, we want to make sure they work in an environment that's free from harassment or discrimination of any kind. If they have an issue, we want the employee to know how to complain about it. And moreover, we want HR to know what the best practices are in handling complaints. And what typically happens after a complaint? A workplace investigation. So we'll go over some best practices there as well. We'll talk about performance management. We'll talk about documentation. And then finally, at the end of the employee's life cycle, discipline and termination. The last best practice that we'll talk about, and candidly the one we'll spend the most time on, will be management training. And I don't mean the type of training that HR typically undertakes, such as attending presentations like these. I'm talking about training the actual managers. If you have a sales department, training the sales managers, training the marketing managers, training the operations managers, the folks that typically don't deal with HR laws on a day-to-day basis. What should they know? How should they be trained? And what the best practices are there. So without further ado, we do have
I'm sorry, before we get too far, I think we're looking at your presenter notes instead of the full slideshow. It's okay.
Thanks for the heads up, Luann. Let me reshare.
All right.
I appreciate it. Is that better?
Yes, sir. Thank you.
Awesome. And while Luann is here, we do have a bit of audience participation in the presentation today in the form of a couple of polls that we will put out there from time to time. And now is the time for the first poll. So Luann, if you would like to put that up on the screen. The poll is this: the following best summarizes my organization's job descriptions. Choose one. We maintain updated, accurate job descriptions for most or all positions within the company. We do not have job descriptions, or we have job descriptions, but they should probably be updated. We'll take a few seconds here so everybody can decide which one they would like to select here, and then we'll show the results.
All right, it looks like we have a good portion of participation.
All right, so the majority is we maintain updated, accurate job descriptions for most or all positions within the company. Fantastic. A small minority does not have job descriptions at all. And then almost 40%, yeah, we have job descriptions, but they should probably be updated. Well, this slide is for that close to 40%, really. The first best practice that I recommend pertains to job descriptions. I'm not saying that you absolutely have to have a job description. I'm not aware of any case that was lost because of the sole fact that an employer lacked a job description. But my recommendation is to have job descriptions and to ensure that they are highly accurate. Update them as you might need to, which may be frequently, it might not be frequently. But here's why I recommend having accurate job descriptions. And I should say accurate and detailed job descriptions. The most compelling legal argument you can make in a case defending yourself against a discrimination or harassment or retaliation case generally is not quoting the most recent case law or citing Supreme Court precedent, although those things are certainly helpful. But to a judge, jury, or EEOC investigator, typically the most compelling argument is number one, we told the employee what the expectations were. Number two, we gave them the opportunity to succeed or to correct any deficiencies. And number three, they didn't meet expectations or they didn't take advantage of the opportunity to improve. How do we establish this argument? Well, number one would be if we have a job description that clearly states what the expectations and requirements of the position are. That's a fantastic start. In fact, job descriptions are usually Exhibit B when I submit a position statement. Exhibit A is the EEO policy, but Exhibit B would be the job description. Here's what the person is expected to do. The other way that having job descriptions can help you is if you are in a position where you have to accommodate a disability. One of the legal criteria is that you must provide reasonable accommodations that enable a person to perform the essential functions of their job. If a person is not able to perform with or without a reasonable accommodation any essential function, they're not covered by the Americans with Disabilities Act anymore. How do you establish what the essential functions of the position are? Well, a job description is a good starting place. In fact, job descriptions in my mind should go hand in hand with performance evaluations. When it comes to performance evaluations, what I dislike are those generic evaluations about, concepts that are abstract, such as, does this person contribute to a collaborative environment? Yeah, that's nice flowery language, but what I'm kind of more concerned about is if I've got a salesperson, are they meeting the expectations? Are they selling enough? I want to have that in the job description, so when I'm doing the performance evaluation, I can rely on the description to say, here's what the expectation is. Great, you're meeting it, you're exceeding it, you're not meeting it. Here's what we're going to do to get us back on track there. Almost 40% said, yes, we've got job descriptions, but we haven't updated them. Well, how should you update them? What are the best practices to actually draft or update job descriptions? Well, one would be in that performance evaluation process. What's the feedback that the employee is giving to you? Are they saying, hey, you scored me really low on this metric, but that's not really my job? Well, okay, maybe we go back to the job description now and modify it to take that away or to minimize what that particular responsibility is. All right, so job descriptions also tend to be a good baseline for number two, hiring and recruitment. You have an opening. How do you market or advertise the fact that you have an opening? Internally, bulletin board. I don't know how many employers still have bulletin boards in the break room, given that we're such a hybrid workforce these days. But when you think about it, you have a position that's open. Do you provide some sort of description of the duties of the position? Yes, of course, right? Should that description be a summary of the job the job description or the description that you talked about in slide number one? Yeah, absolutely. That would be a great starting point. So your best practice number one, updating those job descriptions and having them accurate, helps you now with best practice number two, hiring and recruitment. Here are the tips that I want to convey when it comes to hiring and recruitment. And there's a handful of them. The first one, though, is be mindful of how and where you post your job openings. Let me give you an example. Colorado, Washington State, and many other jurisdictions have laws that say if you post a job that can be performed in Colorado, in Washington, whatever the jurisdiction is, and that job description is available or that posting is made in such a way that it can be reviewed by people in Colorado or Washington, you must comply with pay transparency laws. You have to advertise what the salary range is, or you're in violation of that law. So good example here is you have a remote position, a position that could be done remotely. You just put it out there on whatever platform you want to, whatever .com website. be sure, now you're advertising a remote position that theoretically could be performed by a worker in Colorado, in Washington state. It's on the internet. Somebody in Colorado or Washington can certainly access it and review it. You need to comply with those particular state laws. A quick Google search will give you a fairly reliable list of what those pay transparency laws are and to whom they apply. I pick on Colorado and Washington because they have no threshold limits, such as New York City has an ordinance where you need to have at least 4 employees. It's unclear whether the 4 employees would be in New York City or just in general. But if you're advertising a position that could be performed in New York City and you have 4 employees, you've got to comply with their pay transparency law. But Washington, Colorado, there's no minimum number of employees. It's a very broadly phrased statute in each jurisdiction there. Just be mindful of them. The second best practice is to be sure you're using consistent job-related criteria for evaluating candidates and for setting compensation. The last thing you want to do is be hit with a unfair Pay Act claim where you're paying male employees more than female employees, or vice versa. You want to be sure that you are using consistent and job-related criteria when setting compensation. And what might job-related criteria be? Well, it could be experience level. It could be that the person previously was in an identical role for another company or something along those lines. How do we prove that? Let's go back to the job descriptions and show what the essential functions of the position are. Another best practice for hiring and recruitment is to avoid questions on applications and during interviews that might lead an applicant to conclude there's some discriminatory motive behind the question. And maybe the most obvious and blatant example of a discriminatory question would be to ask for somebody's date of birth. In an interview, are you going to ask somebody, how old are you? Golly, I hope not. That would be trouble with the EEOC. But does your application ask for a date of birth? We might want to scratch that from the application that we're using. And here's maybe a more subtle version of that question. Where did you attend school and when did you graduate? Well, if somebody indicates they graduated from high school or a vocational school or college in 1960, you probably would be correct in guessing that is an older individual who is applying there. Another pitfall might be commenting during an interview on a visible physical impairment, which might or might not be a disability. Somebody walks into an interview with a leg and you ask, oh, what happened to you? Believe it or not, I have seen many disability discrimination claims come in based on off-the-cuff comments that were made during job interviews. While that might not be as blatant as asking, do you have a disability? What the applicant is hearing is, you are already judging me based on some physical impairment that I have. I recently saw a case where an individual was asked during a job interview about whether they were taking any prescription drugs. Well, that's a big no-no. The EEOC even has published some guidance on ADA questions and what's permissible, and that is off the table. You cannot be asking that question. You likewise cannot ask questions along the lines of, hey, are you planning to have kids? And that might come up in the more casual conversation, making small talk before the formal interview starts. But just be mindful. I've seen charges of discrimination where that question was the first in a string of allegedly discriminatory remarks and comments directed towards somebody. So what questions are okay? Well, hey, these are fine. It's okay to ask questions in this format. Can you perform the essential functions of this job with or without a reasonable accommodation? And hey, you know what would be a great idea? Have the job description there to hand to them so they can see what the essential functions are. Can you meet the attendance requirements of this job? Perfectly okay to ask that. And by the way, going back to the best practices on job descriptions, if this is an in-person job, we should specify that in the job description. In-person reliable attendance is one of the essential functions of the job. It's perfectly okay to ask, can you meet the attendance requirements? It's also okay if you are interviewing somebody with an obvious physical impairment or disability, or if they disclose a disability. That's okay. You aren't asking about it, but they can voluntarily disclose. It's perfectly okay for you to ask, are you able to perform this specific task? And in fact, it's okay to ask, can you demonstrate how you would perform this? If you have an applicant at a restaurant for a cook position, line cook position, who has a hearing impairment, and you don't have computer screens, rather you rely on the old school, yelling into the back kitchen, hey, order on table 18 or whatever, you can ask, how would you perform this specific task? Or what accommodation would you need? In fact, if you notice that an applicant is having trouble with the interview itself, it's okay to ask, do you need a reasonable accommodation to participate in the interview process? Perfectly all right. Wrapping up the best practices for hiring and recruitment, let me say a word on background checks. If you use a third party to do like a criminal background check, you must comply with the Fair Credit Reporting Act. Fair Credit Reporting Act basically has 3 requirements you need to be mindful of. Number 1 is you need to get authorization from the applicant before you run that background check. That authorization has to be standalone. It can't be a little line at the bottom of the job application. You have to give them a form that tells them we will use a third-party agency to pull a report that could include, and there's a laundry list of types of reports, including credit reports, which is why the Fair Credit Reporting Act applies here, but also criminal background checks. If you conduct the background check yourself, though, let's say you just want to Google the person by name and see what comes up, or you want to check their social media pages or something like that, and you do that in-house, you don't have to worry about the FCRA. You don't have to get their authorization ahead of time. I mentioned there were 3 requirements. The other 2 pertain to what happens when you obtain information from that background check conducted by a third party that would lead you to not hire the person. You need to send them a pre-adverse action notice that says, hey, the report that we got includes some information that would lead us not to hire you or to rescind our job offer. You have 5 days in which to contest this, not with us, but with the agency that actually did the background check. Here's a copy of the background check, and here's a copy of a form called a summary of your rights under the FCRA. 5 days later, here's the third obligation. You need to send them an adverse action letter that basically says the same thing as the first letter. There was something in your background check that caused us to not hire you or rescind the decision. You have the right to contest this, but our decision is that we're not going to hire you at this time. Here's a summary of your rights under the FCRA. Those are the 3 things the FCRA requires. Now, that does not apply when you are doing I-9 checks or when you are running E-Verify. Here in Florida, probably all of the folks on this call are required to run E-Verify at the beginning of employment. And certainly everybody on this call is required to do the I-9 check, where you ask for documents from List A or from B and C to confirm that the person is eligible to work in the United States. The last best practice I have for hiring and recruitment is to document the hiring decision. Why was this the best qualified candidate? Although certainly not in the majority of discrimination claims that are out there, there is a sizable chunk of discrimination claims brought not by the employees, but by applicants who were passed over for the job. In fact, one of those cases is a case that we'll end the discussion this morning on, that pertains to some AI usage in the recruitment and selection process. So anyway, it's always a great idea when choosing a candidate to document why this was the best candidate for the position, whether it was experience, whether it was ambition, whatever the reason, just have that documented somewhere. Remember, the statute of limitations is fairly long on a discrimination claim, so if you're no longer there, at least there's a note to whomever the successor is that is defending a discrimination claim as to why this was the best decision, the best candidate for the job. Let me move now to best practice number 3, wage and hour compliance. The Fair Labor Standards Act was referenced in the initial slides. If you joined early, you saw Myra had some slides up there about best practices, and one of the references was to the Fair Labor Standards Act. This law has been around since 1938. It requires only 4 things. It requires that you pay employees minimum wage. It requires that you pay employees overtime if they work more than 40 hours in a week, unless, of course, they are exempt. It requires that you comply with various child labor requirements in terms of how many hours they can work and when they can work. Although Florida and virtually every other state has more strict child labor requirements than the federal Fair Labor Standards Act. And then the 4th requirement is timekeeping. You have the obligation to keep accurate records of the hours that your employees work, plus the compensation that they receive. So where do employers slip up? Well, one large section of wage and hour litigation pertains to misclassification of employees, either calling a non-exempt employee exempt when they're really not, and not paying them overtime can result in, frankly, a collective action against the company for anybody that was in that particular job classification that wasn't being paid the overtime because we misclassified them. You can't simply say, I'm going to pay an employee a salary, and that means I don't have to pay them overtime. No, they also need to fall within one of some very well-defined and narrowly defined exemptions to the overtime rule in order for you to avoid paying them overtime. I could probably give an entire hour presentation on exempt versus non-exempt classification, but for purposes of today, I just want it to be on everybody's mind. Hey, if there's that position that I think is kind of borderline and it's been bothering me for a little while, well, maybe now's the time to go back and check, why are we classifying this as exempt versus non-exempt? The other type of misclassification, which I've actually seen quite a bit of over the last 3 or 4 years, is misclassifying a worker as an independent contractor rather than an employee. You can't simply decide that this particular individual is going to be a 1099 independent contractor when they're doing the same work as one of your W-2 employees. The burden is on you, the employer, to prove that a worker is an independent contractor, not an employee. If you get it wrong, the consequences could be, number one, the IRS is going to come to your door because you are the IRS's deputy in terms of collecting income taxes. And if that independent contractor doesn't pay their income taxes appropriately, you, the employer, can be on the hook for that, in addition to penalties, fines, interest, potential jail time if you're a habitual offender, just something you generally don't want to mess with. Other things that could cause trouble would be, well, if you're not classifying them as an employee, you're probably not covering them on your workers' comp policy. That's a big no-no in the state of Florida. That could lead to a stop work order if the state finds out about that. You likely aren't paying your unemployment taxes correctly. And then, of course, if you are treating them as a 1099 independent contractor and not paying minimum wage or overtime, you've got a Fair Labor Standards Act problem on your hands as well. The main issues that I see with minimum wage and overtime, when you have a non-exempt employee, you're trying to pay them correctly. The largest one is off-the-clock work. Employees doing work that's not being counted as hours worked and they're not being paid for it. And I see this issue quite a bit with remote employees, where it's very difficult to track the exact hours that they work. And sometimes there's a reliance on the employee to record their time accurately. But also the before work and after hours work. Many years ago, I represented one of those eyeglass stores, you know, where you go in and they make your glasses within an hour. And one of the opticians didn't have a car, so had to rely on others for transportation, and frequently would not be picked up for an hour after he clocked out. And what would he do to pass the hour? Well, he'd do something to make himself busy. He'd grab a broom and, you know, sweep the foyer entry to the retail establishment, or clean up the break room, but all of this was done off the clock. And eventually the employment relationship ended badly. The employee, as many do, goes to an employment lawyer to say, what can I sue the employer for? And the attorney asks, well, tell me a little bit about what you did there. And it comes out that this employee was working off the clock, sweeping the floors, cleaning the break room. And the employer got sued for unpaid overtime, not paying the employee for all hours worked. And unfortunately, if you've ever had a wage and hour case that I've assisted you on, I'm going to say something that you've heard me say before. If you win $10, if you win $1 in overtime, then you, the employer, have to pay all of the employees' attorney's fees, which by the time you get through trial are generally in the six figures. So just be very, very careful to be sure that you are paying appropriately, that you are monitoring hours worked appropriately, and that you don't allow off-the-clock work. The last bullet point I have here is on timekeeping requirements, and here's what I want to say about that. It is the employer's responsibility to maintain accurate records of hours worked. Many, if not most employers, try to pass along that burden to the employee. You need to clock in and out accurately. You need to record your hours worked accurately. And hey, in many instances, there's no alternative to doing that. That's really the only way that we can track an employee's time. But the black letter of the law of the Fair Labor Standards Act says it is the employer's responsibility to maintain accurate time records. If your employees are not doing so, you need to figure out a way to correct that. Okay, best practices number 4, harassment and discrimination prevention. Well, what are the best ways to prevent harassment and discrimination? The first would be to know what the protected categories are. Discrimination is illegal if it's based on only a few protected categories: race, color, religion, sex, national origin, age, disability, marital status, veteran status. That's really it. If you were to hear an employee complain that they're working in a hostile work environment because the boss makes them actually be on time, that's not unlawful harassment because it's not based on race, color, religion, sex, national origin, age, disability, marital status, or veteran status. That's simply that the employee doesn't get along with the boss. That is not unlawful discrimination or harassment. However, if the complaint is the boss gets on me for being late, but none of the other employees, and I'm the only minority, I'm the only female, I'm the only fill in the blank older worker, that should set off a red flag. Hey, all of a sudden this sounds like it might be a complaint based on harassment or discrimination. The second best practice is to know when accommodations might be required. There are 3 instances where an employer must at least evaluate whether or not an accommodation should be or must be given to an employee. And those 3 situations are when a religion-based accommodation is required or sought or requested, when a accommodation is sought due to an employee's disability in order to enable them to perform the essential functions of their job, or pursuant to a law that I mentioned earlier, the Pregnant Workers Fairness Act, if a pregnant employee or one who has recently given childbirth is in need of some sort of workplace modification or accommodation, you need to evaluate whether or not you must provide that or should provide that. And the final best practice that I have here is something that we'll talk about in more detail in upcoming slides, which is mandatory training. It's always a good idea to train not only management on harassment and discrimination prevention, but also employees. There are clients that I will go to on a regular basis to train their entire workforce on harassment and discrimination prevention. And the tone is a bit different than the tone for management training. Management training is really designed toward identifying when some action needs to be taken, some corrective action might be appropriate, investigation might be appropriate, etc. For employee training, the tone is generally more along the lines of, we want to illustrate what discrimination and harassment might look like so that, number 1, none of you are ever accused of engaging in discrimination or harassment. And also, number 2, so that you, an employee, knows what to do if you feel you've been harassed or discriminated against. We want you to know what the complaint procedure is. And candidly, the clients that I have that do that type of training regularly are the ones that have the fewest EEOC charges. Um, I think simply because it's drilled into the employee that we take this seriously. We want you to know how to raise a complaint. Here's what the procedure is. So let me go to the next best practice, which is complaint handling. It goes hand in hand with discrimination and harassment prevention. But complaint handling to me is even more broad than that. You know, we're talking not just about handling complaints of discrimination or harassment, but any complaint whatsoever. Hey, I think that the processes we use are inefficient and it would be better if we were to try to do this rather than that. Or, hey, my boss made comments that I was deeply offended by, even though they didn't have anything to do with those protected classes that I mentioned in the last slide. Well, what is the best practice when it comes to complaint handling? I'll tell you what courts and the EEOC and juries like to see is an employer that has a open door policy with multiple channels through which an employee can complain. For example, if you have any issue, you can always complain to your direct supervisor. If you don't want to complain to your direct supervisor, you can complain to any manager. If you don't want to complain to a manager, you can complain to human resources. Well, that's not only 3 avenues. I mean, depending on how many managers you have, if you have a dozen managers, then now we've got, well, 14, you know, the dozen managers, the direct supervisor, and HR that an employee can complain to. It's also a best practice to make very clear in your open door policy that employees will not be retaliated against for raising concerns. And here's where we might split hairs a bit. You might say, well, Keith, we don't want to encourage employees to bring bogus complaints. Okay, I get that. We could probably have a line in there that says, you know, there will be no retaliation for good faith complaints or something along those lines. That's perfectly okay. Now, once you field a complaint, chances are some level of investigation should probably be conducted at this point, right? And the best practice is, rather than just do an off-the-cuff investigation, is to actually plan the investigation first. For example, who will conduct the investigation? Maybe 90 or 95% of the time, it would be human resources that conducts the investigation. But there could be reasons why we wouldn't have HR conducting it. Maybe the complaint is about HR. Maybe the complaint was brought by a close personal friend of whomever's in HR, and we don't want the appearance of bias. But it's a question that should probably be at the forefront of any investigation planning session. Then the next thing to decide, what is the investigation going to look like? Is it going to be interviewing witnesses? Do we need to review documentation before we interview anybody? Is this the type of investigation that doesn't require interviews? Maybe it's entirely researching whatever the issue is in a manner that doesn't implicate witness interviews. If we do interview witnesses, what should the order be? Well, many times, but maybe not every time, you might want to speak to the complainant first. One of your questions to the complainant would be, who else do you think I ought to speak to? Interview the remaining witnesses, and then finally end with the accused. I'm not saying this is the blueprint for every single investigation. There might be investigations where you would want to go to the accused first to get their side of the story before interviewing anybody else. But that's probably the exception rather than the rule. Here's the bullet point where I suspect many will walk away saying, Keith, I didn't know that before, or I did and had forgotten about it. I'm glad you brought it up. And that is, should you request confidentiality from a witness? Many times I will be working with HR departments who are conducting investigations, and they come up with an outline of questions and they send it over to me for review and approval. And the first thing I see on that outline or that script is, you know, thank you for meeting with us. I ask that you keep everything we say confidential. Is that okay? Well, the answer is maybe and maybe not. The National Labor Relations Board, which is the entity that enforces the National Labor Relations Act, takes the position that employers can only request confidentiality in limited circumstances when conducting workplace investigations. Why is that? Well, this all goes back to protected concerted activities. If you have attended these labor and employment updates for the last 10 plus years, you've frequently heard me talk about protected concerted activities. What are protected concerted activities? Well, basically, those are activities that are protected by Section 7 of the National Labor Relations Act, which states employees have the right not only to join or not join a union, but also to engage in mutual protective activities. In other words, they are free to talk to each other about terms and conditions of employment. They're free to talk to each other about how bad their manager is. They're free to talk to each other about workplace investigations that are ongoing. However, with that said, the National Labor Relations Board has indicated there might be limited circumstances where an employer is justified in asking for confidentiality. Again, essentially asking them to forego a right that they have under Section 7 of the National Labor Relations Act. When might they be able to do it? Well, if the employer can articulate a legitimate and substantial business reason for that particular investigation, the board will likely say it's okay to request confidentiality. For example, some legitimate business reasons might include the need to protect a witness, whether it's the one you're interviewing or somebody else, from retaliation, or potentially to prevent the destruction of evidence, or to avoid the fabrication of testimony by future witnesses, or maybe to prevent some sort of cover-up. But the employer cannot merely articulate generalized blanket concerns. They must articulate a specific reason why they think one of those four factors might be present absent an instruction regarding confidentiality. That goes hand in hand with a situation where the employee asks, can you keep this confidential? Or I don't want anybody to know. Or you don't have to do anything about it. I just want HR to be aware. I mean, can you ever guarantee confidentiality or non-action to a witness? And the answer is no. What you can do is assure them that the investigation will be conducted with discretion. You know, we will be discreet, but there could be circumstances where confidentiality is impossible, or where action needs to be taken because there's something going on that's not right, whether it's discrimination and harassment, whether it's dumping toxic chemicals in the lake behind the parking lot. You know, there are certain things that once we become aware of them, we have to take action. So in connection with your workplace investigation, another best practice is, of course, to document. Take notes of the witness interviews. Why? Because at some point, you need to come to a conclusion to your investigation. Who do you believe and why? And let's go back to the notes. Here's what 5 witnesses said versus what 1 witness said. I tend to believe the 5 rather than the 1. You don't always have to decide that the numbers win the day for a particular investigation. In fact, sometimes there are no conclusions to investigations. In other words, the end of the investigation can be summed up by saying, well, hey, the allegations could not be corroborated. Well, why weren't they corroborated? Take a look at my witness notes. Everybody we asked, did you ever see Bob engage in discriminatory conduct? They all said no. Therefore, you know, the allegations couldn't be corroborated. And then finally, when you're interviewing somebody, I would always provide a non-retaliation statement. You know, thank you for speaking with us. The company strictly forbids retaliation against anybody who participates in an HR investigation. If you feel that you're being retaliated against by anybody, you know, please let us know. An important question to ask is, how do we convey the results to the complainant? Do we want to meet in person? Do we want to provide an investigation report? Do we want to simply verbally tell them the investigation has concluded? Here's an instance where I can't give a best practice because your answer is going to be different every time. What is a best practice, though, is to make sure you at least address how we're going to resolve this. Sometimes it is better just to have a brief verbal conversation. Sometimes it's better to be a lot more formal. Certainly in a situation where I suspect the employee is papering his or her own file to bring a claim at some point, I'm more inclined to provide an investigation report that their attorney can read, who hopefully will say, ooh, the company's doing everything right on this one. I don't think there's much of a claim to be had here. And sometimes the content of the communication would differ. Sometimes it might be as mild as, thank you for raising concerns. We've looked into it. We're confident that the issue will not arise again in the future. Or on the other hand, there might be instances where we want to provide a lot more details. A frequent kind of slippery slope that I see is when an investigation results in some sort of corrective action, like disciplinary action against the person that was being accused. And the question is, do we disclose that disciplinary action to the complainant? I'm going to say in 95% of the cases, the answer is going to be no. But it's worth at least asking that question internally. Is there any reason why we would want to disclose the corrective action to the complainant? Best practice number 7, performance management. This kind of goes hand in hand with my best practice tip number 1, which is to have accurate job descriptions. Why? Again, many times the best legal argument is we made clear what the expectation was. We gave the employee the opportunity to correct whatever deficiencies there were, and the employee failed to take corrective action. When issuing a performance improvement plan or even a regular evaluation, here's where I like to use those job descriptions. Have the job description as the outline to the evaluation. And if you learn during the evaluation process that, hey, maybe this particular task that's listed on the evaluation or on the description isn't something the position really does anymore, well, now it's time to update the job description. But sometimes you not only need to evaluate on a regular basis, but also implement some sort of performance improvement plan to get an employee back on track. Well, what does a good performance improvement plan look like? In my mind, it tends to have some clearly defined metrics or goals that the employee can tangibly either meet or not meet. The other component that I think is advisable is to have periodic, but regular, I don't mean infrequent, I mean periodic, regular follow-up meetings during the PIP to see how the employee is doing. And I recommend this for 2 reasons. One reason would be, let's say you put an employee on a 90-day PIP, they have no idea how they're doing, maybe the metrics aren't that clearly defined as to what goal they need to hit, and then 90 days later we say, you didn't really meet our expectations, so we're going to let you go. That's kind of a surprise to the employee perhaps, whereas on the other hand, if we put somebody on a 90-day PIP and we make sure that we meet with them at 30 days, 45 days, 60 days, 75 days, the manager can at least give regular feedback. Even if the feedback isn't good, this is advantageous because, in Florida, we are at-will employees unless we have employment contracts. A PIP is not a guarantee of employment for the full period of the PIP. If it's clear after 45 days, 60 days, etc., that the employee is not going to meet the metrics or the goals, why are we going to continue to employ them for another 30 or 45 days? Let's let them go at that point. So anyway, the periodic regular follow-up meetings are beneficial even if it doesn't result in the employee successfully meeting the goals of the PIP. Best practice number 8. This one will be pretty quick. You've heard me say this before. Document, document, document. The most difficult cases to win when you're the employer pertain to the employee who is fired, as they say, out of the blue for no reason. I was a great performer, the best employee the company ever had, and we say, no, you were a horrible employee, and eventually enough was enough when we let you go. Okay, well, where's the documentation to show how awful they were? What do I mean by documentation? It could be anything. It could be a formal written warning. It could be a memo memorializing a verbal warning. It could be an email from the manager to the HR department. Hey, Keith did a lousy job on this. I just want this to go in Keith's file, right? That's fine. We can work with that. Documentation tends to prove a case, and the lack of documentation tends to lose the case. I have a quote here, which was also in Myra's slides at the beginning. If it's not documented, it didn't happen. Judges and juries believe that statement to no end. If it's not documented, it didn't happen. So here's some best practices regarding documentation. Number one is be factual, just the facts. We don't want to include legal conclusions. We don't want to provide opinions. We just want to be factual. Keith has been late for work for 3 of the last 10 days. I'm sending you this memo for his file, right? We also want to be sure that we maintain secure records. I know that we are all moving away from the ginormous file cabinets in the HR office and probably moving toward electronic files. We want to work with IT to make sure that HR files are maintained securely and they can't be accessed by anybody that doesn't have a need to access them. Best practice number 9. Here we are at the end of the employee's life cycle, discipline and termination. Again, I point to one of Myra's slides at the very beginning while you were in the waiting room. More lawsuits are brought due to inconsistent enforcement of policies than really for any other reason. And why is that? Because inconsistent enforcement tends to look like discrimination. And if that inconsistent enforcement is inconsistent between protected categories or among protected categories, that's where discrimination liability exists. So we want to be consistent. We want our policies to be clear. I generally recommend having a progressive disciplinary policy in the handbook that says something along the lines of the normal steps of discipline will be a verbal warning, written warning, maybe a suspension, and then termination. But with the caveat that depending on the seriousness of the offense, any step of the progressive disciplinary policy might be skipped at any time. And I alluded to the third point in the previous slide. We want to avoid surprise terminations. If an employee is going to be terminated over something that has happened over time, like poor performance, as opposed to, hey, we just caught them stealing from the company. That's a one and done, you're out of there, whether it's a surprise termination or not. But if it's poor performance or some other failure to meet a metric, the employee should be aware well ahead of the termination that there's an issue there. And how might they be aware of it? Regular employee evaluations through performance improvement plans. As a matter of fact, I believe this leads us to our second poll, Luann. If you'd like to put that poll up, it pertains to evaluations. My organization conducts regular performance evaluations. Choose one. Yes. Number 2 is we're supposed to, but we rarely do. And the third one is no, we don't do performance evaluations. We'll give everybody 15 or 20 seconds on this one. The poll is also a good way to see who's still with us here and listening intently. How are we looking, Luann? Do we have enough to show the results?
We do. I'll go ahead and launch that.
All right. So good. The vast majority, 69%, yes, we conduct regular performance evaluations. 14 rarely. We're supposed to, but we rarely do. And then the 17% is no. I'm going to just reemphasize here that, hey, congrats on the 70% of you out there that are doing them regularly. That's great. And for the other 31% here, for your consideration, I recommend regular evaluations. And why? So we can avoid those surprise terminations that might lead to legal claims against the company. So the last best practice that I have is management training. Again, not training for the HR folks, but training for the actual managers, the operations managers who are out there who might not know what the law is. In fact, if I'm a sales manager, I probably shouldn't be expected to know even a basic level of the FMLA. And I shouldn't say that they shouldn't be expected. Every manager should be expected to have some baseline knowledge of what the workplace laws are, because most employment litigation is based on conduct or non-conduct by managers rather than by the HR department's decisions. The management as being a best practice also is the best practice to avoid litigation, which is the next section of our training. And let's do a very brief pause here so Luann and Myra can let me know if anybody has had any questions up until now. I'll address them before jumping into the management training component of the presentation today.
Okay, Keith, I've got a couple for you. For job descriptions, do you recommend that employees sign them for their personnel file?
Yeah, I think that's a great idea because it shows, just like with the handbook acknowledgement, that at some point the employee was made aware of what the job description said. In fact, I'd give them a copy too, but yes, having them sign it is a great idea.
Perfect, thank you. Another one on job descriptions. If we choose not to do job descriptions now, are there any issues with creating them when and if we have to engage in the interactive process?
Yeah, so one of the reasons I recommend having job descriptions as a best practice pertains to the interactive process, because the interactive process is designed to evaluate whether an accommodation is necessary and whether it will enable the employee to perform the essential functions of the job. Where does the job description come in to this? Really, it's in determining what the essential functions of the job are. You know, if an employee requests an accommodation, but it still isn't going to enable them to perform the essential functions, you don't have to give it. In fact, they're not even protected under the ADA at that point. So having the job description is a good tool to have in the toolkit to defend against a potential ADA claim or to avoid one in the first place.
Perfect. And then if an employee asks for a term letter, are we required to provide that if it's not typically our practice?
Yeah, that's a great question because I'm going to give you two answers. The first answer is no. Are you legally required? No, absolutely not. But are there instances where you should, even if it's not your normal practice? There could be. And what immediately comes to my mind is, again, if this is an employee that we anticipate is probably cooking up a lawsuit against the company, and we suspect they're about to go talk to the employment lawyer to say, what claims do I have? What can I sue the employer for? It might be advisable to provide a termination letter to explain the reasons for the termination. So hopefully the lawyer says, ooh, you don't have a claim here. The company did everything above board, and I'm not going to represent you.
Okay, I've got a couple on termination, so I'll just kind of combine them. One is, how does surprise termination relate to being an at-will employer? And the second one is, my managers say that Florida's at will, so we can fire anybody for any reason. What should I tell those managers?
I would say that maybe the content is accurate, but the tone could be misconstrued when conveying that message. At-will employment means that either side can end the employment relationship at any time or for any reason, with or without notice, as long as it's not for an illegal reason. Now, it is technically true. You can fire somebody with no warning whatsoever, the surprise termination, right? But why is a surprise termination not advisable? Well, if it's a termination due to poor performance over a period of time, one, meaning the jury, the judge, the EEOC investigator might reasonably ask, why didn't you do anything to tell the employee that their performance wasn't up to par and they needed to improve? Now, granted, again, you find out the employee is stealing from the company, they're out. I mean, that, in my mind, that's not the surprise termination. That's, hey, we're firing you because the conduct you engaged in was so bad that there's no alternative but to terminate your employment. What I mean by the surprise termination is things get so bad over a period of time. Finally, the employer says, I've had enough, and we fire the person, and the employee didn't see it coming. That sends them to an employment lawyer. That's one of the things we want to avoid in the first place. Whereas telling them ahead of time with an annual evaluation, with a PIP, meeting with them during the PIP, I think it certainly reduces the likelihood that the employee is going to go running to the employment lawyer to say, what can I sue the employer for?
Okay. With regards to interviewing, if somebody states they have a disability and we acknowledge it and then we don't hire them, any legal consequences or way to avoid potential legal consequences?
Yeah, so I think the best way to avoid the legal consequences would be to, number one, document why you decided to hire the person that you did decide to hire. And of course, that should not implicate any disability related issue whatsoever. For example, it would not be a good reason to hire Keith rather than Myra because Myra would need an accommodation and Keith wouldn't. That's not a good reason. But a better reason would be decide to hire Keith rather than Myra because Keith has several years more experience, or whatever the legitimate reason is there. The other thing that I would recommend is, of course, let's say you get hit with this disclosure out of the blue. What do? Your initial inclination is probably to say, well, I'm not going to touch that. I'm not going to ask any questions about it whatsoever. I would just remember there are a couple of questions that are perfectly okay. One would be, can you perform the essential functions of the job with or without an accommodation? And job description, here are what the essential functions are. It's okay to ask them to demonstrate how they would perform a particular aspect of the job. Certainly, if it's a physical job and the person is telling you, hey, I've recently had back surgery. Okay, can you demonstrate how you would handle the jackhammer, right? If that's one of the essential functions of the job. Those are okay. And I think the best practice is to know that it's okay to ask those questions, which will help you make the determination as to who to offer the job to, but also to show that you're not asking unlawful questions or that you didn't just shut down the interview and decide not really to consider this person any further in light of their disclosure of the disability.
Okay, I've got one more till we wrap it up. Can you clarify if corrective action from a workplace investigation can be disclosed to the complainant?
So there's no law that says that it cannot be disclosed. However, in my experience, the situations where you would want to disclose that would be exceedingly rare. And I mean, really, we go back to the scenario I described earlier. This is an employee who's building a case against the company, and we know they're going to go to an employment lawyer. We might want to disclose some form of corrective action there. But again, that's like the 1% of cases, the 5% of cases at most. It's not the norm. Normally, you would want to respect, I would say, all employees' privacy by not discussing corrective actions with anybody other than the employee and those with a need to know, like their managers.
Perfect, thank you.
All right. So the second component of the presentation today is avoiding litigation. And I would say that management training is probably the best step that you can take to avoid litigation. Because, as I mentioned earlier, many legal claims are based on a manager's or a supervisor's actions or lack of actions, not necessarily on an HR decision. And managers are rarely experts in HR law, but they should have some basic level of knowledge of applicable employment law. So if you decide after the next few slides that I'm about to show that, hey, management training would be a good idea, one of the questions that you would want to ask is, well, who should provide this training? How should we conduct it? Should this be in-house, conducted by HR? Should this be conducted by Myra or by Keith or some other, third party to come in and do that? And the answer is, hey, that answer is probably different depending on the circumstances. There would be instances where I would be fully supportive of having HR conduct it. This is not intended to be an infomercial for Keith to go out and do management training. But with that said, that's something that I do frequently. That's something that Myra does frequently. What should the management training cover? Well, in the next few slides, I'm going to give you a sample of the type of management training that I typically do so that you can see what the tone and the content of that training is. I'll tell you, there are probably two discrete situations where I am requested to come in and do management training for a company. One would be some manager just screwed up something big time, and we want to make sure it never happens again, right? Maybe the company's been sued for it, maybe not, but nonetheless, we want to make sure that all managers know that you can't do this or that in the workplace. The other scenario, though, is the company has done management training in the past at some point, And kind of as a preventative maintenance tool, they'd like to refresh managers' memories as to what the training covered. And there have been instances where I've gone in and done the same management training only a year or 2 years after doing it previously. And the managers say, "Oh, I'm really glad that you did this. I'd kind of forgotten about this, that, or the other, but this was a good refresher course." So anyway, I think management training is certainly an effective tool, something that you might want to consider. And I have no problem whatsoever if you want to copy the next several slides and use them as your own management training PowerPoint. That is A-OK with me. Here's an overview of what I typically go through in some management training. First of all, I like to explain to managers, we have an open door complaint policy. I like to tell them, what the various avenues are and why it's a good idea. We don't want a situation where you have employees or managers saying, you need to follow the chain of command. Any complaint needs to go through me. Well, what if the complaint is about you? That's the issue that the EEOC is going to harp upon, is that the employer didn't have an effective complaint procedure, and that leads to the loss of various affirmative defenses that the employer could possibly provide. I also like to point out that supervisors and managers are the eyes and ears of the company, and many legal standards are based on whether the company, meaning any supervisor or manager, knew or should have known of unlawful conduct, such as harassment. So, for example, if a manager observes two coworkers, one of whom is harassing the other and does nothing about it, the company can be liable because that manager has knowledge that's imputed upon the company as a whole. And thirdly, I point out that the company's response time can be examined in determining liability. How quickly did the company respond after first becoming aware? And very frequently, the manager who becomes aware is not the HR person or other manager that takes the corrective action. So the gap in time between the manager becoming aware and then letting HR know can work against the company. I point out to managers that they've got 3 duties when it comes to the open door complaint procedure. Number 1, receive the complaint or the concern. You shouldn't be telling employees now is not a good time. You shouldn't have the door closed. You should not be unapproachable. Your second duty is to react to the complaint. Tell HR immediately. Again, 99 times out of 100, HR would be the first stop you'd go to. I suppose there might be somewhere you go directly to the CEO, but reacting is the second duty. And then the third responsibility is to respond to the team member. And that could be simply following HR's instructions regarding communications with the team member, how often to communicate, what the communication should be, or even not to communicate about it, that HR will handle the matter further. Some common problems by managers would be to react by saying, I'm too busy, can you just call HR instead? Or by saying, I don't want to get involved. Or the worst that I've heard, this is a real life one, is you don't know what you're talking about. Your job should be as a sponge, managers, right? Receive the complaint. Just take in what it is that the employee wants to alert you to so that you can then convey it to HR. Other common problems, and hey, this is something that we covered right in our best practices. What if the team member tells you as the supervisor or manager, don't share the complaint, keep it confidential? Hey, look, I want to give the managers and the supervisors the tools to be successful. Here's that base level knowledge that they should have when it comes to how to field a complaint and how to respond when somebody asks for confidentiality. 2 phrases. If anything improper is happening, we need to address it. Number 2, company will be discreet in investigating, but there could be circumstances in which we can't guarantee absolute confidentiality. Best practices for managers: listen to everything the team member wants to discuss. Ask them this question: is there anything else? Is there anything else? I use that question all the time in depositions. Was there anything else? Don't, as a manager or supervisor, render an opinion while the employee is raising concerns. You don't want to say something like, oh, you're right, the company needs to do something about that. No, as a manager, your job at this point is to gather information, be a sponge. And then finally, alert HR. Don't alert others that don't have a need to know. Then I frequently talk about termination and separation paperwork. And this might be a little more on the dry side of things, but I've had employers where the managers fire an employee and don't even bother to tell HR about it until sometime much, farther down the line in the chronology of things here. Here's why it's important to be timely, managers, when you're turning in termination paperwork. Well, for one thing, there's this law called COBRA, right? COBRA pertains to benefits continuation after an employee has been separated. And employers only have 30 days after the termination to notify the plan administrator. The plan administrator then has a limited amount of time to notify the team member of the continuation rights. What happens if you don't do this in a timely manner because HR doesn't know that the employee has been terminated? Well, there could be penalties from both the IRS and the Department of Labor, up to several $100s per day of the violation. But the biggest exposure is, let's say an employee doesn't receive that notification timely. They don't elect for benefits continuation as a result of that, and then they get into a tragic auto accident or some other, onset of illness. The company could have to pay the medical expenses incurred as a result of the team member not receiving a timely notice. So it is super important to notify HR. What happens if an employee resigns? Hey, managers, it's a good idea to ask for a letter of resignation from the team member. Why? Well, for two reasons. One, so that we can establish the date that the clock begins to run for the COBRA notice, but also to show the employee is resigning and not being fired. Many employment law claims are dismissed because the employee ended up quitting and not being fired. So I then like to shift gears into reasonable accommodations. Why? Because many managers lack any training on what is required under the law when it comes to workplace accommodations. Even relatively savvy managers who know that, hey, if I want to avoid discrimination claims, I need to treat everybody the same as everybody else. That's true unless we're talking about accommodations, which by their nature involve treating one person or one group of people better than others, or making exceptions to policies. That's required under the law as a reasonable accommodation, yet is completely counterintuitive even to those that have a pretty good handle on discrimination laws. So I like to ask managers during this training, and frankly, I'd like to ask you guys as well, how would you respond to the following? What if a team member comes to you and says that he's born again and he can no longer work on Sundays? Is your answer no, too bad? Or is the answer, well, let me evaluate that? How would you respond if after you deliver a verbal warning to a team member who's spending 20 minutes at a time in the bathroom, the team member tells you that they have a medical condition that requires that they use the restroom frequently? And then finally, the situation is another team member announces that she's pregnant and asks for the parking spot closest to the building. How would you respond to that? And that gives me a good segue to discuss that there are 3 instances where you might be required to accommodate a person. And those would be if the accommodation is based on a disability or a religious belief or practice, or for pregnancy or childbirth or related medical conditions. I talk generally about what the Americans with Disabilities Act is. I talk generally about how Title VII protects against discrimination based on religion, and how that has been construed to mean that you must provide accommodations unless they amount to an undue hardship. And then I even go into a fairly recent Supreme Court case that says, hey, if you are going to deny a religion-based accommodation, such as I don't want to work on a Sunday, you need to show more than simply, well, hey, I'm not going to do that because other employees would be required to work overtime. Supreme Court said that's not an undue hardship. You must show a substantial increase in cost or impact on your operations before you deny a religion-based accommodation. And then I go over the Pregnant Workers Fairness Act. I tell them what it is, and I give them the laundry list of, hey, here are the accommodations that the statute itself says you need to provide. One of those would be the closer parking spot, bullet point number 2 there. So then we go back over the 3 scenarios. Hopefully we come up with the correct answer, which is that we at least need to evaluate whether the accommodation request poses an undue hardship or not. And I go over some common problems. One would be a manager not even realizing that a team member is requesting an accommodation. Accommodation request is not always in the form of a question, right? It could simply be, ooh, I'm having trouble, sitting at the desk for 4 hours at a time. Uh, my sciatica is acting up or something along those lines. That needs to be treated as a trigger to the interactive process. Is there some accommodation that we can make that would enable you to be able to perform that essential function of the job? Another common problem that I point out to managers is when the manager doesn't notify human resources of the accommodation request. And here's where I discuss with them that HR is really the repository of all institutional knowledge. They might be aware that another employee in another department made an identical request 6 months ago, and here's what we provided to that employee, even if this manager doesn't know anything about that. We want to be consistent in providing accommodations under like circumstances, and that's why it's important to get HR involved immediately. And then finally, a problem would be, the manager denies a requested accommodation without even conducting an undue burden analysis. We go back over those first three questions that I gave, and I said if your answer was a gut reaction no to any of those three, that could be problematic, right? We need to go through the interactive process. I'd also like to go over just the basics of FMLA leave, telling them what the base level thresholds are for employees to be covered, telling them what conditions are covered or what type of situations might entitle an employee to FMLA leave, how much leave they're entitled to. Serious health condition, I spend a little more time on because that's probably the most common instance where an employee is requesting to take FMLA leave. And what I also like to go over with them is, hey, here's what the company's obligation is. Once we become aware that an employee might have a need for FMLA leave, we've got to send them some paperwork within 5 business days. And if we don't, we're on the hook for what they call FMLA interference. So a common issue is when a manager or a supervisor knows that a team member has missed 3 days of work, but they don't notify HR. Well, hey, that's one of the triggers for FMLA leave, serious health condition. And I point out that the FMLA is strict liability, that if we don't provide even that bit of paperwork, we're on the hook for damages there. I also like to point out that FMLA leave can be taken incrementally. I discuss what intermittent leave is, what a reduced work schedule might look like. And I am clear that the FMLA generally prohibits employers from disclosing specifics of a team member's condition to managers and supervisors. If you, manager, get a call from HR saying that Luann is unable to work Wednesday afternoons from now until the foreseeable future, there's a reason they're not giving you further information. And the reason is it's probably an FMLA condition and the law prohibits the HR from telling you what the specifics are about the need for leave. I go into some additional common problems. I discuss what the difference is between interference and retaliation, but I leave on this note, which is that the FMLA is one of only a couple of employment laws, the FLSA being the other one, where managers and supervisors can be held liable in their individual capacity for FMLA violations. So let's go back a couple of slides. Hey, we realize that an employee has been out of work for 3 days and I didn't notify HR, and that led to the employee not getting their notice within 5 business days. My name can be on the lawsuit as a defendant. If the company is found liable, I can be found liable. I can be forced by the court to have to pay the damages and the other side's attorney's fees for that FMLA violation. So it's a pretty eye-opening slide when we go through that during the management training. I also like to discuss the probationary period and progressive discipline. Kind of a common problem that I see from time to time is an employee not doing well during the 90-day probationary period, but the employer, for whatever reason, waiting until day 92 or 93 to take action on it. I mean, hey, I suppose that's okay because we're an at-will employment state, right? Does it create any greater exposure for discrimination claims or harassment, retaliation claims? No, probably not. But there is one bit of exposure when you wait beyond the 90 days. Here's what it is. All new hires are subject to a 90-day probationary period. And the reasons for the probationary period are essentially to decide whether this is a good fit. But the 90 days is a hard deadline when it comes to the exposure I'm about to tell you about. The company will not be charged for unemployment benefits when an employee is terminated within the 90 days. So on day 90 or earlier, if the employee then goes and applies for unemployment benefits and they get the benefits, your account will not be charged. But if the new employee is terminated on day 91 or later, the company will be charged for the unemployment benefits. Maybe that's not a big deal. Maybe it is. It kind of depends on the size of the employer and how many unemployment claims it gets every year. And if you are a large employer, it could be fairly significant. You know, your tax rate goes up based on the number of claims that are made against you for unemployment. So the key takeaways that I like to give supervisors: know when that 90-day probationary period will end. And if the team member is not a good fit, consult with HR before day 90 so the company can be prepared to separate the team member. I also like to go into the company's progressive discipline policy and essentially let them know that, you know, typically you would want to go through all of these steps, but the level of discipline could be implemented depending on the seriousness of the offense. I like to remind the team members this is also a time when you would want to discuss with HR before deciding this is bad enough to fire somebody. Again, HR, repository of institutional knowledge. They know whether there's been somebody who is engaged in similar misconduct in the past and how they were disciplined. And this is a two-way street, too. Maybe the supervisor thinks, yeah, this is bad, but not bad enough to terminate somebody over. And HR realizes, whoa, 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 we've had this come up twice in the past and we've terminated every time. We want to be consistent in our application of the progressive disciplinary policy. Yeah, I just covered that. So when it comes to management training, you've hopefully seen that the tone and content that I typically provide is to encourage collaboration with the HR department, that HR is not the bad guy, that there are certain things that HR can't disclose to managers, and there are legal reasons why, but also that HR is a partner, and managers should not be the lone wolf out there. They should be consulting with HR to make sure that policies are applied consistently, particularly when it comes to discipline. So, like I said, please feel free to copy those. That's generally not the entirety of the management training that I do. I frequently customize it if there was a specific need, if there was a specific incident that led to the need for training. But as you see, it's not all just very dry legal discussion. It's really geared toward being an effective manager and working together hand in hand with HR. So the last topic I'm going to go over pertains to AI. And I know one of the issues that Myra has talked to everybody about, and I've talked to many of you about over the last couple of years, has been implementing some form of AI policy. And what I've kind of seen over the last couple of years is that maybe there's no one-size-fits-all AI policy. Maybe what is best is to evaluate how your company is using AI, if at all. And what I have seen, this is my own observation, I'm not saying it's uniform across the board, is that AI is being used more and more in the hiring and recruitment process, in particular in winnowing down the applications that come in to identify who the best candidates might be. There have been two rather significant cases pertaining to the use of AI in the workplace since ChatGPT and the others really came onto the world stage here. The first one is a case called EEOC versus iTutor Group, Inc., which was filed in New York. In that case, iTutor Group was a Chinese-based company that hired Americans to work as tutors for Chinese nationals who were seeking instruction on English as a second language. And China, believe it or not, does not have the equivalent of Title VII or the Age Discrimination in Employment Act. And internally, it said, we do not want to hire males over the age of 55 or females over the age of 45. They didn't make that publicly known, but they were using AI to sift through applications for the position. And some older applicants observed that they weren't being hired despite having better credentials than younger candidates. And eventually they brought an EEOC charge, which the EEOC, this is under the Biden administration, said, ooh, there's not only smoke, there's fire here. We think there is age discrimination going on, that it's systemic, meaning it's applicable to more than one person. We, the EEOC, are going to sue iTutor Group ourselves. And during the discovery process, it came out that yes, in fact, iTutor Group was setting as the parameters within its AI platform, basically to weed out any older applicants. And again, with the ages themselves came out during discovery, 55 for males and 45 for females. This lawsuit resulted in a settlement, not an adverse verdict. But as part of the settlement, if any of you have ever had to settle a case with the EEOC, you'll know it's about more than just paying money. Frequently, it's about agreeing to provide certain data to the EEOC on periodic bases, to telling employees we discriminated in the past, and if you feel you're being discriminated against, here's who to contact. Well, in this particular case, the EEOC really laid down the hammer. In addition to a $365,000 settlement, part of the settlement was that iTutor Group would not do business in the United States anymore. So they literally took away one of the largest markets for iTutor Group. The second case is still ongoing. The second case is Mobley versus Workday. Mobley is an African-American gentleman over the age of 40 who has a disability and applied for somewhere between 80 and 100 different positions with employers who used Workday as their software platform to cull out various applicants, or to narrow down the applicants that it would actually go on to interview. Mobley's basis for the age component of his claim was that he indicated what year he graduated from college on his resume. His race discrimination claim was based on the fact that he went to a historically black college or university. I believe it was, I don't want to say and get it wrong. I think it was Morehouse, but I could be wrong. Anyway, he brought suit alleging that this AI platform was discriminatorily weeding out himself and other candidates based on race, based on age, based on disability. It's a little unclear how he claims that the software knew of his disability, but nonetheless, what Workday argued was, hey, we're just the vendor. We don't put in what the criteria are for coming up with who a good candidate would be or not, and winnowing them out of the selection process. And the court rejected that argument. The court said, hey, you're just as liable as the employer who inputs these discriminatory parameters here. The case went up on appeal, came back down on appeal after the Ninth Circuit, which is out on the West Coast, basically affirmed what the district court's decision was, meaning Workday has to stay in the case as a defendant. And since that time, the case has been certified as a nationwide class action. So you'll likely see this case in the news at some point in the future, either when it settles or when it goes to trial. But that's kind of the illustrative case of what the dangers of using AI might be in the context of hiring decisions and selecting who to get past the application stage. So with that said, we are near the end of the time for my presentation, but we have built in plenty of time for any additional questions. So let me turn things back over to Myra.
Okay, we had a couple. If an employee has a fear of animals and you have a dog that comes into the office, do you have to accommodate that fear?
In other words, does the human take precedence over the animal? And the answer is, I tell you this from a legal standpoint, not necessarily from a moral standpoint. The government takes the position that the animal wins, that the person with the fear can be moved to a different part of the facility. The person with the disability necessitating the dog takes priority.
What if it's not an accommodation thing? It's just a preference that we are okay with having critters in the office and an employee is in fact scared of them. So it's not a service animal as much as it's a company mascot.
Yeah, so that's an excellent illustration of the difference here, because unless it is a service animal, unless the animal is there because of somebody's need, the animal doesn't take priority. Now, I'm not saying that necessarily this employee takes priority, because it's unclear whether the fear of animals is something that amounts to a disability, which could be a mental impairment as well as a physical impairment that affects one or more major life activities. I can see situations where this could be a disability, but also situations where it might not. And if it's not a disability on either side, I mean, really, the employer is free to make whatever decision it wants.
Okay, perfect. And then also, if someone's out on FML because of workers' comp, can we make the employee use their PTO in conjunction with getting paid workers' comp, using PTO, and being on FMLA?
Yeah, so the answer is technically you are supposed to only require PTO with the employee's consent, but most employers obtain that consent by saying in the FMLA policy that your PTO will run concurrently with FMLA leave. I would follow whatever your policy says. If the policy says your PTO will run concurrently, you can still make them use the PTO even though it's a work-related injury. Once the PTO runs out, then the indemnity benefits might kick back in again.
Okay, perfect. And then is remote work required to be offered for a pregnant person asking for it? So
Yeah.
like if they get morning sickness.
That is one of the accommodations specifically listed in the statute. The only way that you would be permitted not to offer that is by showing an undue hardship. And for a short-term stint of remote work, I think it would be kind of difficult to do so. Maybe not impossible. Certainly, if there are circumstances we want to discuss offline, we can do that. But I would say generally, a, a short-term period of remote work would almost always be required.
Okay, perfect. Well, that was it for our questions. Thank you, everybody, for participating. Thanks, Keith, for walking us through how to stay safe out there.
Absolutely. Thanks, everyone.
All right, bye.